I would say docket. Mr. Medina?
Yes, Your Honor, I have one out of custody. May I call him?
Sure.
I'm sorry, Your Honor. Mr. Collier, Gavin Collier. Mr. Collier is number 7 on the 130 docket, 23 CF 2579. He is going to enter a plea of not guilty. He has a PTI offer. He's going to set up a meeting and we'll go over it. He's also going to complete the public defender application before he leaves the courthouse today.
Okay, so we'll continue this on 2/12, 9 a.m.
Okay, so I'm just writing that down for you. 2/12. That's your next court date, okay? Thank you, Your Honor. I think that's my only out of custody. Thank you.
Mr. Gates, do you have any out of custody?
No, Your Honor.
You want to try and do those two that were,
There's some unrepresented, Your Honor. What the court wants to call those.
you want to do those two?
We can, Your Honor.
Why don't we? Is Malik Humphreys here? Okay, just come up to the podium. So would the state announce the case, please?
This is State versus Malik Humphreys, case number 23 CF 2577. Mr. Humphreys is charged with possession of a weapon by a convicted felon, or possession of a firearm by a convicted felon, POCS, resisting an officer without violence, false ID given to a law enforcement officer, and petty theft. I've spoken with Mr. Humphreys ahead of today's court day, and he knows that it's a 3-year DOC midman offer. So my understanding was he wanted to speak with you.
So, Mr. Humphreys, first of all, you do have a right with these new charges to have an attorney appointed if you cannot afford one.
Yes, sir.
Do you wish to have an attorney appointed at this point?
I
You can
was.
always substitute if you,
Yes, I had talked to Larissa Dudley.
okay?
I had already talked to her. So,
So are you going to hire her?
Yes, sir.
Okay. Okay, so do you want to continue this? Or we can just take a plea at this point, enter a not guilty plea in your behalf, and come back on 2/12, on February 12th at 9 a.m. In the meantime, you can get up with Miss Dudley. She knows
Yes, sir.
that's the pretrial, it's the next pretrial. She'll know that that's the next one. And
Yes,
she
sir.
can begin the process and give you your options, et cetera.
Yes, sir.
Okay. Mr. Losco, anything?
No, Your Honor, thank you.
Okay, any questions, sir?
No, sir.
Okay, thank you. And then is Larry Jordan here? Would you come forward, sir? Would the state announce this case as well?
Yes, Your Honor, this is State versus Larry Jordan, case number 23CF 2407 with 2 counts of POCS.
We don't want to start, you guys are starting to get to use those acronyms. Use the acronym, a lot of people don't understand those acronyms. So go ahead and spell it out.
2 counts of possession of controlled substance.
Okay. So, Mr. Jordan, as you heard me state, the prior defendant, you do have a right with these new charges to have an attorney. If you cannot afford one, one will be appointed. Are you wanting to have an attorney appointed, or are you going to hire private counsel?
I'll hire one.
Okay. So what do you want to do today? You want to enter a not guilty plea and come back in the
Yes,
next
sir.
pretrial? Okay, so court will enter a not guilty plea and we'll come back on 2/12 and 9 a.m. for your next pretrial. Try and get your attorney hired by then, and communicate with them so we can get moving on these. Okay?
Yes, sir. Thank you.
Okay, thank you very much. There you go, Mr. Gates. 3 is the bird.
I'm not, Your Honor. Ms. Taylor from this morning's docket.
Okay. Where'd Mr. Medina go?
We need to talk with Ms. Cooper. I think there's a plea agreement he was going over with her.
Ms. Sharpless, who was handling Taylor this morning?
I was.
You-
That was Mr. Lawson.
Were you able to get in touch with the probation officer?
Yes, Your Honor. Probation Officer Howell graciously was willing to come on in.
Okay, good. Would you want to go ahead and want to do that?
I can do that right now. Before we come.
Let's do it. Are you ready to go?
Yes,
You
Your
wanna
Honor. Can I approach with the score sheet? Or
go?
do
You may. No, please do.
you want me to wait until she's out here? That way she...
No,
Taylor.
you can't. What is this? Okay, thank you. Thank you. I assume, Mr. Gates, you've
Yes,
seen
sir.
the score sheet.
Yes, sir. It's the same score sheet that I told the court
Sure.
about earlier. 41.2 points.
Okay. So, Mr. Gates, do you wish to make, and allow each to have opening remarks and have any witnesses? Do you wish to make an opening?
Yes, Your Honor. As I stated earlier, the original goal for Ms. Taylor was to try and get her out through a negotiated plea agreement. We tried a couple of different variations of a plea agreement. Unfortunately, the state's position was, the policy that I was informed of was given to the fact that she scores roughly 41 points, 41.2 points. It would be a 12-1 DOC. They were not willing to consider reinstatement or a county jail sentence. That might have gone down to 1129, depending on which state attorney I was discussing this with at the time. Ms. Taylor has asked the court to consider a county jail sentence, a little bit less than the year in the county jail. I talked with the jail during the break. Roughly speaking, Ms. Taylor, with transport time, has about 155 days or so credit. That would roughly work out to about a 6-month county jail sentence. I think given the score and the score sheet, a 6-month sentence with credit would be appropriate. I know Ms. Taylor is concerned about losing her home, as well as her children ended up in custody of Department of Children and Families in Georgia. So that's what we're asking the court to consider this morning.
Make sure I'm following you, because you stated a couple things.
Yes, sir.
One, the state's position is 12-1, and you're arguing for, some lesser, obviously, county sentence. But the minimum score sheet here is no prison, right? No jail.
Yes, Your Honor.
I was just wondering, I want to make sure I was understanding what I'm reading here.
Yes, Your Honor. She's in a discretionary range. 22 to 44 points is discretionary to the court.
Right.
It was usually my experience that in that range we were negotiating county jail sentence of some length. Recently, the state attorneys changed the policy on county jail and violations of probation. I think that's subsequently changed since Ms. Taylor was originally brought through. I think it is now either a DOC or CC reinstate, but I don't think Ms. Taylor qualified for that based upon the nature of the allegations.
Okay. Very good. Okay, anything further as far as your,
Not for opening, Your Honor.
okay. So, you wish to make an opening?
Your Honor, regarding opening, I would just say that the state believes that 12-1 DOC is appropriate. Not only well, I'll say this, I recognize that she doesn't score. I understand it's up to this court's discretion, but the state's position is that the 12-1 is appropriate here. That is in part largely because this was a gun charge initially, and she only completed 2 months of probation, and then she VOP'd, and she was in the wind for approximately a year. The state intends to call the probation officer, and we believe that there will be testimony regarding why she's not an appropriate candidate for probation. And I don't believe a short jail sentence is appropriate for this either, given the fact that it wasn't just a gun charge, but it was also the intentional VOP. So that's all I have for opening, Judge.
Very good. Okay. Do you wish to have any witnesses?
I think I would call Ms. Taylor to address the court, Your Honor.
Okay. I'm going to go ahead and swear you in again, even though I think you're sworn in this morning. You raise your right hand. Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
What do you want the court to know?
That I did not intend to violate probation. I did stay in contact with her, and I got a job at Tyson, so I was working, and so that's the reason I didn't report. I made contact with the Georgia probation, and they come to my house twice, and I went there. I was at work. They left a card on my fence, and then she gave me like 2 weeks or something like that to report.
Who's she?
Miss Howell. And because I had just got this job at Tyson, making like $23 an hour, I was working, and, you know, I didn't want to mess that up, and so, no, I didn't report, so I made that mistake. But when I got pulled over this time, my kids was at school, and so when they pulled me over and put me in jail, you know, my kids got off the bus, and then I'm not there. So my neighbors got my kids, the neighbors at my house, and my friend's been paying my bills for the last 3 months, but he said he can't keep doing it. And my neighbors are not going to be able to just keep taking care of my kids. I got an 11-year-old and a 16-year-old. So I'm asking you to just please give me another chance, because like I said, I did not intentionally do it, and I was staying in contact with Ms. Howell.
When you say you were staying in contact,
I was calling.
tell me, I want to be specific about what you mean by that, or what you're saying.
I kept calling her.
So you kept calling her when during the time frame? Because there was the initial period of time, and then there was a warrant that was issued, and then you were gone for,
Yes,
you
after
didn't even
she
show
issued the
for.
warrant, I called her like once or twice, and I asked her if there was any way that she could give me a waiver, or if I could pay something, or, you know, if she could do anything like that and let me know what I was looking at. And she said, no, ma'am, I'd have to go before the judge, and then I just continued taking care of my house and working. I was working when they pulled me over in Dothan, and then when I crossed back at the state line, they pulled me over in Blakely, Georgia, and then Florida had a hold. Florida put a hold. But I was putting the self-checkout kiosk in Walmart in Dothan.
So when you're saying you were trying to stay in touch with Ms. Howell, how many times, when you say you're trying to stay in touch, you said?
I called her
Like
2
you
or 3
say-
times after the warrant was issued, and tried to ask her if she could maybe give me a waiver, or, you know, let me know what I could do. And she said, no, ma'am, it'd be up to the judge. And then, I'm not gonna lie, after that, I continued on with working and trying to take care of my family, and then when I got pulled over. But I had called her 2 or 3 times and asked her, and she said that there was nothing she could do, that I'd have to come before the judge.
Okay. Anything else? Mr. Gates, anything else?
Prior to the warrant, were you staying in touch with Officer Howell?
Yes, sir.
No other questions?
Between the time, the initial, when you started on probation, and the time the warrant was issued, that was only a couple of months, right?
Mhm.
So during that period, you said you were also trying to stay in touch? Or
I
you
was
were
staying in touch with her, yes, sir.
And what does that mean, staying in touch?
I was calling her,
How often?
like once a week sometimes.
Were you reaching her once a week?
Yes,
Or
sir.
you just trying to call
No,
her
I
once a week?
just spoke with her.
You spoke with her once a week for the 2 months
Yes, ma'am.
before
Yes, sir.
the warrant was
Yes,
issued?
sir.
Okay.
And even after the warrant was issued, I tried to contact her and see what I could do about it. And she said that it would be up to the judge.
No other questions, Your Honor.
Okay, thank you.
I have a few questions. Ma'am, how many times have you been on probation in your life?
Once,
Once,
twice, counting this one.
twice, counting this one. When you said that you called the officer after the warrant was issued, how many times did you call the
2 or
officer?
3 times.
In 12 months, you called her 2 or 3 times.
After she told me I had to plea out to the judge, I didn't know what else to do because I kept calling her. And then I left her messages, but I spoke with her 3 times, and every time I'd ask her, she'd say that there was nothing she could do, that I'd have to plead out to the judge.
And so you made a decision just to ignore all of this?
No, sir, I was working, trying to take care of my family. I would have come back, but I didn't know exactly how to take care of it. I didn't know what to do.
No further questions.
Anything further, Mr. Green? Any other questions?
Just one follow-up.
Sure.
The other probation you mentioned, how did
That was
that
on
end?
9 years. I completed it.
I'm sorry, I didn't hear your answer.
You completed that
I had
probation?
9 years probation for burglary, for stealing a plant out of abandoned house's yard. So it was something stupid, but I completed it. Yeah, I got a plant out of abandoned house's yard, and I pled out like I did with this, to 9 years probation, but yeah, I completed it.
Okay,
No other questions, Your Honor.
thank you. Who do you wish to call?
The
Ms.
state
Howell?
would call the probation officer in this case, Ms. Howell.
Ms. Howell, will you come forward to the witness stand? And thank you for coming up here on such short notice, ma'am. Appreciate it. Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Please be seated. Mr. Losco, you may inquire.
Thank you, Judge. Ms. Howell, I'm just going to remind you to speak into the microphone. Please state your name for the record.
Samantha Howell,
How are you employed?
with the Department of Corrections.
Okay. And what do you do for the Department of Corrections? Where do you do these?
I normally supervise sex offenders and those coming out of prison.
Okay. And
I know it doesn't seem like it, ma'am, but if, you got to talk right into that. That mic is you're not talking into, you got to talk right into it.
Okay, I'm sorry.
See how you can actually hear when you talk. This is a directional mic. It's really sensitive. Sorry, go ahead.
ma'am, during your tenure with Department of Corrections,
And
were you-
how long have you been a probation officer?
About 9 years.
Thank you.
Thank you. During your tenure, were you tasked with supervising a defendant by the name of Andrea Taylor?
Yes, sir.
Okay. And how did she do on probation?
Not very well.
Can you give me details?
She was placed on our leave in June 22, if I recall correctly. We got her reporting instructions to transfer to Georgia. And while the transfer request was pending, she failed to check in with Georgia as instructed.
Okay. Can you tell me anything else? Let me be more specific, ma'am. Ma'am, how long did she remain on probation without a violation?
About 2 months.
Okay. And then what happened at that 2-month period?
I kept getting conflicting information that she was staying at this residence and she wasn't staying at this residence, and so I really had no idea where she was staying at, because she kept claiming she was. A man named Johnny, and then Georgia kept telling me she wasn't staying at this residence, so I ultimately had to end up responding.
Okay. And when you filed that VOP and you absconded her, did you communicate that with the defendant?
I communicated, after the warrant came active, I don't recall having any further communications, but before the warrant went active, I recall having a communication with her, letting her know that she was in violation status because of that.
Okay. And so with the testimony earlier that she communicated with you approximately 3 times after the warrant became active, is that true?
I don't recall, to be honest with you. I don't have a note of that in my system, and being so long ago, I don't remember.
Okay. Is that the type thing that you would create a note in your system over?
Yes, sir.
Okay, thank you. Ma'am, do you believe that it's appropriate if she's put back on probation?
I feel like it would be a cycle. We would do this again.
Why?
She failed to, she was given a timeline to check in with Georgia. I ultimately got it to where she could check in with the office. It's a report up there, and she failed to do that.
Okay. And I want to be specific here. When there was this discrepancy as to if she's actually living at this address, was there a time where you set up an appointment for her to check in with Georgia probation?
Yes, sir.
Okay,
Well, it wasn't necessarily an exact appointment, it was a time frame. She
Okay.
had until a certain date to check in.
okay, so, and can you tell me what happened did she check into Georgia probation?
No, sir.
Okay. Give me one moment. Okay, did she give you a reason why?
She originally told me that she had COVID, but she never communicated to me beforehand that she had COVID for me to attempt to extend the timeline.
At any point did she tell you that she's working at Tyson Foods?
She told me she had a job, but she never specifically told me where.
Okay. I think that's everything. Thank you, ma'am. I pass the witness.
Mr. Gates.
Afternoon, Officer Howe. During the 2 months, how was the communication with Ms. Taylor?
It was very good.
Was she easy to get a hold of when you attempted to call her?
Yes.
And did she call you on a regular basis?
Yes.
And I think I think there was a misunderstanding. Prior to the warrant becoming active, there is a period of time where the warrant's been submitted, correct?
Yes.
During that time frame when it was submitted to when it was active, is it possible that Ms. Taylor called you a couple of times, 2 to 3 times?
Yes. I know I did spoke with her after I had submitted the violation and before the warrant came active. I know I did speak with her then.
And during that time frame, do you remember if the conversation was about what she could do to avoid having to come back to Florida?
I don't recall.
Now, the information you got from Georgia probation, that was actually through the system like ICOTS, correct?
Yes, sir.
So there was no direct conversation with a Georgia probation officer, right?
No, sir.
And
unusual?
No, sir. We have been told by our upper management not to directly speak to them, but through this website system called ICOTS, that we direct talk to them through that.
And the time frame that you gave Ms. Taylor, was that about 2 weeks?
I believe so.
And that's what she said earlier, you gave her 2 weeks?
It was about that.
No other questions, Your Honor?
Could I just understand, because there was apparently you, using your term, you absconded her,
Yes, sir.
and there was some issue of where she was living.
Yes, sir.
Can you explain that to me? Because it was kind of a peculiar.
So, when she originally checked in, she gave me an address. I don't recall exactly what the address was at this moment. And that she lived there, and I verified that with her sister, that she did live at that address. Well, then at some point, Georgia came out and put a card on the gate, and then they denied her transfer because they didn't get a hold of her. Well, then I spoke with some gentleman, I believe his name was Johnny. I couldn't remember his last name. He was a friend of theirs, and he said she doesn't live there. Well, then Georgia eventually told me that she doesn't live there either. But when I spoke with the sister and her again, they continued to give me the same address. So I had to go off of Georgia. Georgia told me, according to my
So you
manager,
did speak with Georgia?
through the ICOT system.
So what did Georgia say?
That they went out to the residence, they couldn't find her there, and so she doesn't live there.
And Johnny was
The neighbor.
somebody,
He was either a family friend, a neighbor, or I'm not exactly sure the relation. I was just given his number of another person that could confirm she lived there, who did do that.
sure. Mr. Lasko, did that prompt any other questions?
No, Your Honor, thank you.
Mr. Gates, did my question prompt any questions?
Once Georgia basically said that she did not live there, did they have any more interest in doing any supervision with her?
Not with that if I provided the same address.
No other questions, Your Honor?
Okay, very good. Thank you, ma'am. And is Ms. Howell excused? She doesn't have.
Yes, Your Honor.
You're welcome to leave. Thank you. Any other witnesses, Mr. Lasko?
No, Your Honor.
Okay. Mr. Gates, any closing?
Your Honor, I think in my opening I was concise. Again, we're not asking to put Ms. Taylor back on supervision. I don't think really anyone is asking that. I think Ms. Taylor has kind of seen the tea leaves as far as that's concerned. Obviously, if that was the court sentence, she would abide by all those conditions. She does have an address of, I think it's 400 Smock, South Mock. I say Smock, South Mock in Georgia that she could reside at. Her sister also was offered a place for her to stay if the court was inclined to do that. However, I think it really is an argument over the appropriate amount of incarceration. We don't have a situation in which Ms. Taylor got out of jail and didn't report to probation. She reported to probation. She went through the process of having it transferred. She went through the process of getting a travel permit. She stayed in touch with the probation officer during that time frame. And much to my chagrin, she didn't keep the course, and when things got a bit tough, it fell apart on her. And I think she said that it did, and she decided that it was more important to try and support her family. Albeit, hindsight, I would say that she would rather probably have taken care of it as soon as she could. But again, we're not asking the court to dismiss the BOP or anything like that. We were asking the court to consider a 6-month county jail sentence with a prior credit that would allow Ms. Taylor to get back home somewhat quickly, to be there to support the kids and to potentially save her house. I know that that's been her big concern. And I think in the long line of things that we've had before the court, maintaining good contact is one of those things that the court makes sure they understand, and I think that's what we have here. Obviously, getting scared of a potential weighs heavy on some, and Ms. Taylor made the wrong decision, but she's admitted to that and has asked the court for mercy this morning.
Mr. Lawson.
Judge, I believe that we're all in agreement here that supervision does not make sense moving forward. I do not believe that this defendant would be amenable to supervision, especially based on the testimony by the probation officer who graciously came in here. I believe that we are arguing over how much incarceration is appropriate. The state's position is 6 months is not appropriate for this case because the underlying offense was a felon in possession of ammunition. In addition to that, a point came after she pled guilty to that charge where this defendant made a decision. That defendant decided to abscond and decided to ignore all of this, ignore this court, ignore the fact that she knew a warrant was out for her arrest, and continue about her day until eventually they picked her up. Now, I understand that it's not convenient to be away from your children. I understand that it's the holidays. I understand that no one wants to sit in jail. But also, I would say that when she made her decision to abscond, she knew one day she was going to get picked up for this, Judge, and one day she was going to have to pay the piper. And today is that day. And the state's position is that 6 months is not enough for the underlying charge and for her decision to completely and blatantly ignore probation and violate. The state believes that DOC is appropriate here upon a review of her criminal history, upon a review of the underlying offense, and upon a review of this violation and her decisions in this case.
Very good. Anything else? Mr. Gates?
Yes, Your Honor, and again, the underlying charge, because the state has addressed that, 5 rounds of ammunition in the trunk of a vehicle with a passenger. We're not talking about a situation in which Ms. Taylor was running around waving a firearm and even found a firearm on her. Ms. Taylor admitted. Ms. Taylor pled to those charges, so that ship has sailed. But the state keeps harping on the fact that it's a firearm, it's ammunition. Yeah, it's 5 rounds of ammunition in a trunk. I would also state that...
Was this her car, or was this her car that the ammunition was found? Or was she the passenger in this car?
I'd have to ask her, Your Honor.
I was a passenger, but I pled out to the 3 years probation.
Okay.
And just to touch on that, if the court remembers early the bond, I mentioned sometimes clients enter pleas of convenience. This was one of those situations. And again, the state of Florida has kind of decided that we have a sentencing guidelines, and they've taken a lot of time into consideration in making those. And even when you look at that sentencing guideline, Ms. Taylor doesn't score a mandatory DOC sentence. She scores roughly 41.2 points. That's a discretionary sentence. Typically, that is a situation where we're talking about county jail. There are egregious situations, which I would concede, I think, need to be in DOC. Ms. Taylor is not one of those. I would point to the fact that she doesn't score. She did stay in touch with her probation officer during the time frame leading up to the activation of the warrant. And again, we're not asking the court for time served, let her out the day. We're saying sentence her to 6 months. I know the general area and the calculation of time, but we're asking the court to punish her to 6 months in the county jail. Just because she's got that much time in doesn't mean that it's an unfair sentence. Had we resolved this for 6 months at the beginning, she would have had to serve that at that point. So early on or later in the case, I don't see much difference between a 6 month sentence. I think 12-1, given the nature, is a bit heavy-handed. And so that's why we've asked the court to do a 6 month jail sentence.
Very good. Well, I thank both parties. Reasoned arguments. When the court has what I call difficult cases, and this is difficult for a different reason. Some cases that criminal judges have that are difficult are based on large sentences. Those are also difficult cases because we're putting people away for a long time. And other times, they're difficult because they're tough calls. This is a tough call. And when I receive tough calls, what I try and do is rely on the law. So I'm going to go to the sentencing guidelines and the discretion that the court has. There is no question that Ms. Taylor, I think, I'm going to couch my words carefully. I'm not saying you were stupid, but I'm saying you did something that was stupid by not coming in for a year. And that absolutely is grounds. And that's the thing, that's the sticking point. That's absolutely grounds to even give you a DOC sentence. However, the court has to take all things into consideration. And the court does take into consideration, the difference between having 5 rounds of ammunition and a firearm, and the use of the firearm versus the, being in possession and how it's in possession. All those things have to be looked at. The court also has to consider exactly what happened. And I'm struck by the fact that, but for contact with the probation officer, as best I can tell, when you were absconded for that year, you did exactly what probation would be wanting you to do. Get a job, support your family, and stay out of trouble, which is exactly what you did. And you stupidly, not you being stupid, but stupidly, didn't find a way to connect, even though there was some confusion with Georgia, and it's always difficult to do it across state line, all that taken into consideration. So the court takes all that into consideration, and the court does find that, I agree with both parties, that a probationary, any further probationary is not what's called for here. It just won't be helpful. The court does find there is an incarcerative sentence that is required. The court's sentence you to 6 months in the county jail. You will get credit for time
So
served.
much.
Okay?
Thank you, Your Honor.
Thank you very much.
Thank you very, very much.
Probation terminated?
Probation is terminated.
Yes, sir.
Thank you.
And I don't know what, I mean, all the costs, you have 6 months, a year to pay.
If we could do 12 months, Your Honor.
12 months to pay any costs, then it goes to collections. That's an important time frame because you really need to pay it during that year, because if not, they might go after your license, your driver's license, and I know. George is anything like we are here in Florida, you don't got a license, you're kind of screwed. So,
Thank you so much.
okay.
Thank you, Your Honor.
Do the right thing and take care of your kids.
Thank you.
And that concludes my
Thank you.
business before the court about me being excused.
I'm sorry?
That concludes my business about me being excused.
And Your Honor, may I be excused as well?
You may. Thank you very much.
Thank you. I'll see you tomorrow.
Yes, sir. Tomorrow or Thursday?
Thursday.
Am I missing something? I said, I hope
Well,
not. I hope we
Judge,
don't have any hearings tomorrow.
All these days are just blending.
I
You
understand.
know, at this point, if I say I'll be here tomorrow, that's a pretty good shot, you know. Court every day.
Mr. Medina,
He may be talking, there was a couple that had asked to speak with him, Your Honor.
He's ready, please.
With the court.
let's go ahead and take a short break and then just text me and I'll be on the line.
All rise, please. Court is in recess.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with? I think I was bit by a vampire. This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires.
No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaceTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with? I think I was bit by a vampire. This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch.
Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists.
This is a limited appearance by me because the public defender has filed a motion to withdraw that apparently hasn't been acted upon, dated December 11th. So she would just enter a not guilty plea and be set on February 12th pending, and then get a notice of who the next lawyer is going to be.
Very good. So as soon as it comes through, try and meet up with your lawyer before it's February 12th.
Yes, sir. Thank you, Your Honor.
Okay, thank you.
Cooper? Your Honor, Ms. Cooper was on the morning docket, Lashai Cooper.
Got it.
22 from the morning docket, 23 CF 1557. And Ms. Cooper is signing an agreement that we have been over and that was worked out with the state. I got it. And the state signing it, Your Honor. Okay, that's fine. She's adding. Yeah, well, yeah, that'll be, I will. Your Honor, I think the state added a little technical language. I got to make sure Ms. Cooper and proceed. Okay. May I approach, Your Honor?
You may.
Actually, I do need to make a copy because we added that language. Yeah, I'm sorry, Your Honor.
That's right, thank you.
Your Honor, advising probation, there's a little bit of technical language that was added that we'll go through, kind of standard stuff, but just please listen.
Okay.
Your Honor, under this agreement, Ms. Cooper will be entering a no contest plea. And by the way, I would kind of footnote is that I've advised Ms. Cooper that if she went to trial, it's possible, or continued to fight the case, it's possible we could reach a better outcome, because she's taken 2 felony charges, and she may have a defense or some sort of excuse, but this is a plea that she is able to enter today that will get her out of jail today. She thinks it's in her best interest, and I've advised her of her options. Under the agreement, Your Honor, there will be adjudication of guilt as charged, 1 year concurrent community control, followed by 2 years drug offender probation with a 7 p.m. to 9 a.m. curfew. That's subject to approved work exceptions, and the curfew, the 9 p.m. to 7 a.m. curfew, applies when she's under drug offender probation. And there's a note clarifying that, because when she understands when she's under community control, it's house arrest, so she's in essence under a 24-hour curfew during that period of time. No violent contact with Theodore Johnson, who is her father, who is the alleged victim in count 2. Substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days. Mental health evaluation within 60 days with any recommended treatment to commence within 90 days. $967 court costs, $150 public defender fees. The state has agreed to waive the cost of supervision. She's going to have a lot of costs associated with the substance abuse and mental health evaluations and treatment. No firearms, no drugs not prescribed during supervision. Maintain gainful employment or complete 2 applications a week.
Sharp, I'm impressed with your writing. You don't normally write too much out, so you can actually read it. Mr. Medina, one question.
Yes, sir.
Just point of clarification. I think I know the answer to it, but I think we may need to put it in the agreement. You have basically the sentence, but you don't say which count it applies to, or whether this is each count has the same sentence. Because is it 1 year community control for count 1, or for count 1 and count 2? What about the others?
1 year concurrent community control, so it's intended to say concurrent between both counts, and then followed by 2 years, I should have said 2 years concurrent drug offender probation, and the associated conditions are applicable to both counts.
Okay. Can you?
I'll write concurrent after before the drug offender probation.
That's fine.
Is that okay?
Sure.
Thank you.
Yeah, I'm pretty much. I kind of read between the lines. I knew what you were trying to say, but we need to make.
Yes, and then just clarifying is that I said Theodore Johnson is her father, and it's no violent contact, but also, as I understand, she lives with him, so she'll be able to go back and she'll be spending most of her days when she's not at work. She'll be living in that house, right?
Yes.
Okay. So, Ms. Cooper, would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. The state in agreement with this, I see.
Yes, Your Honor, that is the state's agreement.
So, you heard your attorney state the terms of your plea agreement. I see those same terms are in the written plea agreement that you have signed.
Yes,
So
sir.
my first question is, did you read this closely? You read the plea agreement?
Yes, sir.
And did you go over it in detail with your attorney, make sure you had all your legal questions answered regarding this plea agreement?
Yes, sir.
You understand, importantly, you're waiving some valuable legal rights. Like your attorney said, you could kind of continue this, kind of fight it, you might even get a little better deal, whatever. But you believe that by waiving those rights so you can get a final resolution, that that's in your best interest to take this deal today.
Yes, sir.
You're not being forced to. We can hold off on it. I just want to make sure you're clear this is what you want to do.
Yes, sir.
Okay. And you have had all your legal questions answered by your attorney?
Yes, sir.
Okay, very good. Based upon that and the score sheet, you're okay with, Mr.?
Yes, Your Honor.
So, Very good. Ms. Cooper, based upon your testimony, the court will accept your plea agreement. The court will, there'll be an adjudication of guilt on both counts, okay?
Yes, sir.
And for each of the counts, you are to receive 1 year community control, followed by 2 years drug offender probation. These will be served concurrent. So they're not going to stack on top of one another. They're basically, it's a total of 1 year community control plus 2 years of drug offender probation. It's a total of 3 years, right?
Yes, sir.
Okay, and on the drug offender probation, you have a curfew of 9 p.m. to 7 a.m. curfew. You can make some exceptions for work, but you got to work that out.
Yes, sir.
There's no violent contact, which means there is contact with Theodore Johnson. It allows you, if you even reside together. But there will be a substance abuse evaluation that's required within 30 days and start treatment within 60 if they say it. Mental health evaluation within 60 with any recommended treatment to commence in 90 days. 967 court costs, 150 PD fees, public defender fees, waive cost of supervision. The other things, no drugs, no firearms, maintain employment, etc.
Your
The
Honor,
state agrees not to file on the FTA.
thank you. On the FTA, I think I had forgot to announce that, so thank you.
And look, I'm just going to throw this out there. I don't sound like I'm asking a question knowing the answer, and I don't. Actually, I thought I do. You have the substance abuse evaluation taking place before the mental health evaluation.
I think that was intentional.
I know it was, but I thought the consensus was to do it just the opposite. That it would,
We can do it in
mental. I'm not pushing for it. I want to make sure we're being intentional that we're purpose. That's the best way to do it. Because we should probably do it all the same. I mean, it shouldn't be from case to case.
A lot of times the mental health is done first. I assumed that based on the information, the feedback we've had from, there had been mental health court and drug court input to the state. So I think the state was intentionally prioritizing, in her case, the substance abuse. But.
Okay.
Yes, Your Honor.
At least it's intentional, and that's what I wanted to make sure that we're not just kind of slopping it up, because it does matter sometimes the sequence. Because these services, of all the stuff that's involved here, I know you're worried about getting out of jail. Good for you. But what's really important is the long term. Long term. We don't want to see you in orange anymore. You've got enough people in the jail, right? Plenty of people in the jail. We want to keep you, want to be out here, being with your family and doing the right thing.
I have a question. Well, what about if I'm already in Bridgeway, getting medication and mental health and substance abuse thing? Can I just...
You just talk with your probation officer, and they'll help kind of direct it if that qualifies. And it might, but I don't want to say here definitively. I don't know exactly what it is that you're talking about. But if you've already been evaluated, you're already in treatment, then they'll look at it and say, well, that checks that box off.
Okay.
Okay, but you got to check with them. Don't say, well, judge said I can check that box off. Don't go. Work with them and figure out what's necessary. Okay.
Okay.
Any other questions?
No, Your Honor. I had advised her right when she gets out, other than immediately reporting for your community control to commence. To call Bridgeway and make both appointments right away and see which one you can get into first, because it's going to be, there are waiting lists, and don't delay.
Okay.
And if you're already seeing them, they may accept that, but you never know. Bridgeway may say, well, I need you to start over with this or whatever. So sorry.
At least you're already in working with Bridgeway, and that's good. That's positive. So you understand the system a little bit, because they've got a lot of good people over there. You got to know how to navigate it, right?
Yes, sir.
Okay.
Thank you. All right, good luck. You got to see him. Thank you, Your Honor.
John, can you get Malcolm Brundage?
Got it. Malcolm Brundage?
Your Honor, Steve Medina with Malcolm Jermaine Brundage, docket number 5, 23 CF 2598. I'm advised that the state's offer is going to be DOC. There's nothing that can be done today to get him out of jail, and we would enter a not guilty plea and ask to be put on or remain on the February 14 docket.
Very good. The court will enter a not guilty plea on behalf of the defendant, continue the matter till the pretrial cycle on 2/14 at 9 a.m.
Thank you. What's that? Does the state recall the precise offer at this time? It was, I think it was guidelines. I can't remember what the time was.
Pull it up because I don't know what the guidelines were.
Yeah, of course. Yes, sir.
I remember that this in
Yeah, I just didn't want to guess. I've been known to confuse people. Hunter Steve Medina with Ricky Kaysen, docket number 6, 23 CF 2519. And you know, Your Honor, at this time, Mr. Kaysen is signing an agreement that's been worked out with the state to resolve his case. Thank you.
This is going to be. Once in a while, one of those pops up.
Sure I got it right. I'm sure I did. Does the state have a spreadsheet?
I sent it over.
Oh, no, I do have a spreadsheet. Thank you. Thank you.
Thank you.
May I approach, Your Honor?
You may.
I think I made a copy, but I'm just going to make sure.
Thank you.
Your Honor, under this agreement, Ricky Kaysen will be resolving the charge with a no contest plea. There will be adjudication of guilt, and that's as charged. That's on a felony illegal dumping. The resolution that's been reached would be for credit for time served, $515 court costs, $150 public defender fees, and he would have 6 months to pay prior to the monetary obligations to going to collections.
State?
That is the state's agreement, Your Honor.
And you're okay with the score sheet, I assume?
Yes, Your Honor.
Sir, Mr. Kaysen, would you raise your right hand, sir? Do you
Yes, sir.
swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
I've got to ask you a couple questions to make sure you know what you're doing here.
Yes, sir.
So you heard your attorney state the terms of your plea agreement. I see those same terms are written out here. So have you read this and
Yes,
gone
sir.
over it in detail with your attorney?
Yes, sir.
Pretty straightforward. It's an adjudication of guilt, get credit for time served, and get out today.
Yes, sir.
Right?
Yes, sir.
And there's court costs and whatnot. You'll have 6 months to pay before it goes to collection. That's important, because if you pay it before that, you know, you're not going to get your dinged on your license.
Yes,
If you
sir.
don't pay it, they might come back and try and take your license.
Yes,
You
Your
understand
Honor.
that?
Yes, sir.
Okay. So you understand this will be a final resolution of your case, and you're waiving the right to go to a trial.
Yes, sir.
You believe that's in your best interest?
Yes, Your Honor.
Okay. I think you're right. Based upon that, the court will accept your plea agreement here today. The court will adjudicate you guilty of the charge of illegal dumping, and you will get credit for all time served. That's your sentence, credit for time served.
Yes, sir.
You're assessed $515 in court costs, $150 in PD fees, and you'll have 6 months to pay before
Yes,
it goes
sir.
to collections.
Yes, sir.
Any questions?
No questions, Your Honor.
Okay, good luck, sir.
Thank you, Your Honor.
Thank you.
I just direction Mr.
Mr.
Pace.
Medina.
All right,
Okay.
take care.
Pace.
Who do we got next, Mr. Medina?
I'm not sure he's in the queue, Your Honor. I think the only ones we had on 1:30, did we already enter a not guilty for Michael Brown yesterday? Or did he, is he here?
He refused transport.
Oh, okay.
Boss?
So we're ready to, we can go forward, Your Honor. if the
So what are we doing with Michael Brown if he didn't? We continue this to another arraignment, or we?
Information has not been filed in all the cases.
It has not? Okay.
Which-
So it's not been filed.
Which case has it not been filed? 23 CS 1673, 2566, 2577, 2569, 2571, 2571, 2009.
So why don't we just continue all of these until our next arraignment?
Your Honor, they might, I don't know if they've, that was up this morning. Sorry. So you should have been filed.
Your Honor, if to save resources, if an information has been filed, we'll probably do a written plea of not guilty. But in the meantime, if we could have a control date of the next arraignment, that's fine.
I agree. Let's just go out to 1:16 and 9 o'clock. Excuse me, 1:30.
And I
We have
apologize.
arraignment on, or the 18th? One of them.
16th, we do have.
Okay, so on January 16th at 1:30.
And I apologize, Judge. He has a slew of cases, so it was hard to keep up with which case. And I think he had 2 more cases that,
And sometimes they're e-filed and they
then
just
that
don't
haven't
show up
made it
right
yet.
away.
Yeah, that's all right. No problem.
I will check on that.
Yeah, you will get those filed by the
Yes,
next
sir.
time, I'm sure.
Your Honor, regarding the 2 evidentiary hearings.
Whoa, before you do that, I got one more that I want to ask you about. You got, I suspect, I've got a Gregory Irvin, that's one of your clients that's not an inmate.
He has a private lawyer filed a notice of appearance, Larissa Dudley, on December 18th, according to a note that I have.
So she filed, for the state's benefit, she filed a not guilty written plea yesterday, so for your notes.
Yes, sir.
So no need for that one today? Very good, thank you, Madam Clerk. Okay, that's all I've got for the arraignment, Mr. Medina. We've got 2 sentencings. Are they both yours?
Yes, Your Honor. Alexander Boss, we would plan to go first.
Okay.
And then we are going to need to go forward with that one. And then Booney, we also need to go forward with. I think Boss's will be a little quicker, but I think they'll both be pretty quick.
Let's do Mr. Bossie's first up.
Your Honor, I have nothing further for today. May I be excused?
You may. Thank you. Do you have anything on Thursday?
No, I don't believe I do Thursday.
Merry Christmas.
Merry Christmas.
I know Miss Sharpless does. So she gets her Merry Christmas on Thursday.
So you're not coming, you won't be here on Thursday?
No.
Yeah, happy holidays.
Thank
Best
you.
wishes to your whole family.
Thank you, you too.
All right, I'm going to sit here, Mr. Boss. That's your table there. Your Honor, is it okay if he sits down?
Yes, you may.
Thank you.
Do we have a score sheet on this? I was looking in the file. Maybe I overlooked
It
it,
was
but I
a plea
couldn't
to the
find it.
bench, so we need a score sheet today just to put the court on, everybody be aware what the situation is. Let me just make sure I showed him I don't think the score sheet has changed, Ms. Sharpless, since the state filed it. Yes. Your Honor, it does have a little bit of circling of case numbers, but it is not in any way not the accurate score sheet of the state. If I may approach, Your Honor.
You may.
Thank you.
And the defense is okay with the score sheet?
Yes, Your Honor.
Okay. So, we're here on plea to the bench, earlier plea and sentencing agreement. And based upon my review, it's as to case number 22 CF 800 and 23 CF 677. As part of the plea agreement, 23 CF 676 was dismissed, being duplicative or something like that.
Yes, sir.
And we're dealing with a plea to the bench with a concurrent cap of 12.6 months DOC. Okay. Does the state wish to make an opening?
Yes, Your Honor. To be brief, the state is requesting the 12.6 months in the Department of Corrections. It believes it's appropriate. The victims have been truly affected by these theft offenses, in addition to the fact that Mr. Boss has some other criminal issues going on, not just in this county, but in other counties. The state does believe that a Department of Corrections sentence is appropriate in this case, and we'll be asking the court for the same.
Ms. Medina, you wish to make an opening remark, or you wish to just reserve it for?
I would like to make just a brief remark just to kind of set the stage. Mr. Boss will be testifying. I think he's not a man of many words, so I wanted to say a few things before he testified, Your Honor. First is that he's served a lot of time in jail on this. I'm not sure how many months, but it's a substantial portion of the 12.6 months he already has in. But since he's been incarcerated, he's been in the, well, I'm not sure how many months, but he's in the Emerald Coast Life Center pod at the jail, as I understand, and he's been doing very well with the treatment that he's getting with basically accused drug offenders, with a very good program that I was really happy to hear it's helping a lot of people while they're at the jail. So he does apparently have some out-of-county holds. It's would be easy to do a DOC sentence, but it would not be good for his recovery, and it would not be good for society. So he's hoping the court will allow him to do Barstib at Phoenix House. He has been accepted to Phoenix House. It would be continuing to build on the progress that he's made in the ECLC pod at this jail. I think that's about it, Your Honor.
Let me ask you this: is this a downward departure, and does it require, well, I'll just ask, is it a downward departure, and does it meet, are you arguing that it meets any of the criteria for a downward departure, if downward departure is required?
Yes, Judge, these are new law charges, and he does score a slight, a very slight portion of a point above 44. And we have the drug offender probation statute that he would be under, Your Honor. He is a chronic substance abuser. I'm trying to grab the statute as we talk, but I will find that, Your Honor, momentarily. But that does give us a mitigating factor it's not one of the ones that's specifically listed in the score sheet, but it is a approved and recognized alternative to incarceration that allows the lowest permissible prison sentence to be avoided.
And what is that called again? Or are you going to be talking about it more?
I'm trying to pull it out, Judge. I'm sorry.
That's all
I had it the other day, and I've got a bunch of cheat sheets here, and it's called the drug offender probation statute. And I'll be able to find it on my phone. But basically, as long as you're 60 points or less, then I think you had to have had some prior experience with drug charges. I'm sorry?
948.20.
What?
948.20.
Yes, I must have attached my copy somewhere else, Judge. I'm sorry. I'm pulling it up on my phone. That's correct. So 948.20, if it appears to the court upon a hearing that the defendant is a chronic substance abuser whose criminal conduct is a violation of 893.132A or 6A or other non-violent felony. If such non-violent felony is committed on or after July 1, 2009, and notwithstanding 921.0024, the defendant's criminal punishment sheet total sentence points are 60 points or less, the court may either adjudge the defendant guilty or stay or withhold adjudication. He understands he would be adjudicated guilty, so that's not going to be an issue. But basically, it allows the court to impose a drug offender probation that's more or less case specific. In a situation like his, where the person has been accepted to Phoenix House, which is a long-term 12 to 18-month program, then that's considered to be an appropriate, special, defendant-specific drug offender probation format. And we've been doing that for a long time, Your Honor, and that is a good way to allow an offender to get treatment and build on their, in his case, some progress that he's made while under custody.
Very good. Ms. Sharpless, are you wanting to call any witnesses?
No, Your Honor, the state does not have any witnesses.
Mr. Medina, would you?
Yes, Your Honor. Do you mind if Mr. Boss comes to the stand, Your Honor? Because my box is kind of in the way. Thank you.
Please raise your right hand. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Your Honor, may I ask the court, can I have that score sheet back just to, I might need to look at it while I'm questioning the witness. Thank you. Would you state your name, sir?
Alexander Boss.
And what was your last residence address not incarcerated?
53 Rudy Home, Florida, Destin, Florida, 54541.
Okay, and was that with your then wife, who's one of the victims in your cases?
Yes.
Okay. And you're no longer married, is that correct? Or are you still?
We're still technically married.
Okay, yes, sir. It looks like from your prior record that you did have a prior sale, manufacture, deliver charge. Is that correct?
Yes, sir.
Okay. And before we get into kind of going forward, let's talk a little bit about your past. Where did you grow up?
I grew up in California.
Okay. And how long have you been in
Florida?
Northwest Florida?
About 12 years.
Okay. And it's kind of a difficult subject, but are you a chronic substance abuser?
I would say that over the last 5 years, I would definitely have become a chronic substance abuser, yes.
What was your drug of choice? Not that you wanted to do it, but what were you most addicted to?
Methamphetamine, followed by heroin.
Since you've been, okay, well, how severe was your drug problem?
Over the last 5 years, I have made a number of really bad choices that led me to lose almost everything and everyone that I loved or cared about, including my wife, my home. I did whatever was necessary to maintain myself, I guess.
Okay.
And it was the most harrowing experience to come out of that while incarcerated in Alabama and to realize just the extent of what I had done.
May I approach back with the score sheet, Your Honor? What did you did some time in Alabama penitentiary, is that correct?
Yes, sir.
What was that for?
That was for possession with intent charge, followed by another possession charge.
Okay.
As I said, I made some bad choices. I took off from Florida and the reason why I have some stuff in other counties.
Okay, I don't want you to, because you're not in those other counties, Your Honor, I'm trying to wall that off because I don't want him to waive his Fifth Amendment privilege in any other counties, okay? But is it fair to say that you've had a history, especially in the last few years, of drug-seeking behavior?
I've been using methamphetamine for over 10 years, but heroin has just been the last 5, and that really is what spiraled me out of control.
Okay. So you've done some drug-seeking conduct to get money for drugs. Is that fair?
That's right.
Okay. Before we get into going forward, do you have anything you want to acknowledge with respect to the victims in the current cases in Okaloosa County, Florida? Because I understand these are people that you know well. What if they were here, what would you want to say to them?
I'm sorry. I definitely understand the meaning of remorse. I mean, I wish I had never been a drug addict so that I wouldn't have had to inflict the pain and suffering that I did on them. Some of those people involved, they cared a lot about me. So I destroyed that trust just to make sure that I would take care of myself, which is not what I would ever want to be. Being sober now, it's a very I would like to say that I'm sorry, and that if there was any way I could take it back, I would. Unfortunately, I can't.
Have you been consistently incarcerated? You came from Alabama to here, and then we're facing these charges that were.
I've been incarcerated for almost the last 2 years.
Okay. And okay, all right. What was your total sentence in Alabama? Do you remember?
Yes, sir. There was a 5-split 1.
What does that mean?
It means that there's a 5-year sentence where you do 1 year in prison and then you're released on parole for an additional 4 years behind that. If I violate the next 4 years, I go back to prison for the rest of the 5.
Okay. All right. Now, and if you at any point you have anything further that's on your mind or on your heart that you want to say, I'm going to give you that chance, certainly at the end. But let's talk about the work you've been doing on recovery while in the jail. Would you tell the court what's been going on while you've been in the jail of a positive nature?
Okay. So I have become a born-again Christian. It's a point of happiness for me. You know, and I mean, just being able to be surrounded by people who are also trying to fix themselves has been great. You know, we've been able to share with each other and learn Scripture, and I feel that that is a good foundation, a good forward point for myself. I mean, I've been in the ECLC class for a few months now, followed by moving to the dorm just a few weeks ago, which is great. We have a structured day in a structured environment, and really I think I need some good structure in my life. So,
in fact, you like that pod with that special program so much that one of the things you had asked me to consider was whether the court would allow you to stay there for an extended period.
Yes, sir. I had actually asked for $11.29 credit for time served so that I could stay there for the additional month of time that I would have left before I would have to go to Walton or Bay County. But it's not, well, we decided that wasn't exactly the best option. Me and the rest of the guys in the pod, we actually talked about it and decided that if I ended up getting sentenced to Phoenix House, that I could minister to the people there as well, since it's not a Christian-based program. I could actually be a light in the darkness, so to speak, since I'm trying so hard to change myself. It would be a good way to affect the ministry and discipleship side of the Christian faith.
So you think you can be a good influence on some others that are going through similar struggles of yourself?
I can tell you that me sitting here now, I'm never going to be a user again of any kind of drugs. I definitely need rehab so I can help my structure in my head, so I can have some ways to deal with some of those problems, the other parts that are left there. But I mean, being able to do outreach to people, I have a great story. I feel like it's a bad story, and I feel I'm embarrassed and all kinds of other stuff right now, but it's something that helps you build past it, you know, realizing that you did wrong and trying to move forward.
Right. Now, again, I don't want to talk about the substance of any charges in other counties, but if you are on hold in Bay County and Walton County, is that right?
Yes, sir. Something
along those lines. So if the court here were to sentence you to bars to bed, Phoenix House, you're anticipating you might transfer to some other counties, and you're hoping that you will wind back up here and be in bars here until you can get your bed in Phoenix House. Is that?
I do believe that the other two counties would go in line with the initial rehab decision. I've actually heard back from Bay County already about that. So,
okay. What more do you wish to tell the court? And you don't have to say anything more. But if there's anything more that you wish to say.
I mean, hindsight is 20/20. You know, I feel remorse for my actions, but all I really can change is the future. I want to become a productive member of society. I want to actually be useful for myself and for people around me, to help other people who are addicted to realize that there is a better way.
And the pod that you're in particularly, and even before that with the group meetings, is that one of the first times you've ever had in your life that kind of feeling of bond with other people who are going through this struggle?
Well, I'd never decided to ever go to NA or AA or anything like that before. So yeah, it was a new experience, a welcome experience, really. Once I got over the initial, I guess, shyness of talking about this stuff with other people.
Right, and, okay. I don't have anything further. Thank you, Your Honor.
Ms. Sharpless?
I do have a few brief questions, Your Honor. So, Mr. Boss, would you agree with me that at the time that the warrant for these cases came active, that you were on probation in Walton County for grand theft auto and some other charges?
Yes.
Okay. And also currently, as you just stated, there's another charge in Bay County that you also need to deal with, is that correct?
No, it was just the violation of probation.
Okay, so there's another violation in Bay County, okay.
Yeah.
And as a part of your sentence in Bay or Walton County, either one, were you allowed to go to the Jada House?
Yes. Okay. Yes, I did go to Jada House.
Is it true that you were actually staying at the Jada House at the time that the warrants for these cases came active?
No.
Okay, so
I had left Jada House.
Okay, so where did you leave Jada House and go to?
I was living on the street. Somebody I ran into had brought me some drugs, and I fell victim to it. I mean, the Jada House is in an area that is very closely intertwined with a number of drug dealers, and it was very easy once somebody figured out that I was there to grab me and say, hey.
So, I guess maybe I was incorrect. So were you in the Department of Corrections in Alabama when these warrants actually became active? Is that where you were? Or when you found out about the warrants?
I found out about the one warrant, I guess, when I left Jada House, and then the other ones, yeah, I guess I was in prison in Alabama.
So did you, is it accurate that you didn't voluntarily agree to be extradited back to Florida?
See, this is interesting. I was never given a piece of paper to sign stating that, the motion of extradition. Nobody ever brought any of that to my attention. They did bring me the 3 governor's warrants when they were issued, but...
The state of Florida had to do a governor's warrant for these cases, is that correct?
3 separate ones.
And Miss Jones you and Miss Jones are separated, but you guys are technically still married, is that correct?
That is correct.
Okay. Your Honor, I don't have any other questions at this time for the witness.
Medina, final question.
Just very quickly, the Jada House, where was the Jada House?
Fort Walton Beach.
Okay, all right. Do you have anything that would share any insights into your experience there and how you feel that you would do better going forward at Phoenix House, and you've done better while in the program at the jail?
I guess the best point to make in regards to that is that it was in the middle of the area that I was previously operating in. I knew all of the people that lived in the area that did drugs, all the drug dealers, and everybody else in between. Marion County, where Phoenix House is, I don't know anyone there at all. I don't actually know anyone that's in the program personally from the streets either. And that's a big deal to me. To be in an area where I don't know where any of the drug houses are or anything like that, it would make it... I just don't feel that it would be an issue there for me to actually stay with the program. Not to mention there were people that were at Jada House that were actively using drugs in each of the houses. It was just not a good experience. Like, I was very quickly in and then out of that program with no support.
I respect what you were saying when you, on direct testimony, when you said you were not going to go back to using drugs.
Yes, sir.
But you do realize that, well, why do you need to go to Phoenix House if you're completely cured of your addiction or whatever? Not trying to minimize, but can you put this in context? Your will to be sober versus your coping strategies and anything else.
So I said earlier that I lost my wife and my home, right? So I don't have any ability to maintain or work or even move about here. I actually don't have contacts either. So I'm currently legally blind. I can't see anyone in this room clearly. going to Phoenix House would not only give me the structure that I need to properly work moving forward, it would allow me to be able to move forward with a job, a vehicle, and everything else all taken care of simultaneously. Whereas if I just took DOC time, not only is the DOC time going to be detrimental to my brain, but when I get out, I'm just going to be me by myself, no contacts, no job, no ability to do anything, and how easy would it be for me to just go right back to what I was doing before? I don't want to do anything with distribution of anything, no drugs, nothing like that. I want to completely take my life in a different pathway, and I feel that going to Phoenix House is actually going to do that. Because they take the time to make sure that you work, that you develop a work ethic.
Thank you. I didn't ask you this on direct, but do you have children?
No, sir.
All right, thank you. Nothing further.
You said you're legally blind. Did you mean that
I think
figuratively, or did you
without contacts? It's clear at this point.
Okay, so you have some issues with your eyes. You don't have.
Yes, sir.
Did you have contacts before and you've lost them, or did you ever have them and your eyes have gotten worse?
No, I had contacts before, and they have. In the separation, they were supposedly sent to my mother, but they weren't. So I don't know where they are.
Okay.
They probably got thrown away, but I cannot see currently.
Okay.
Your Honor, I'm sorry. I assumed it was metaphorically. I appreciate the court clarifying. Sometimes you've got to ask that extra question, so it's a lesson to be learned. Thank you.
That's not metaphorical.
Okay. Thank you, sir. You may step down.
The defense doesn't have any further witnesses, Your Honor.
The state wishes to make a closing.
Yes, Your Honor. So, Your Honor, the state is requesting of the court that Mr. Boss do the called for time in the Department of Corrections. As I attempted to explain to the court the timeline from my understanding of the event, Mr. Boss was on probation in Bay and Walton County for felony charges. Our probation officer, Officer Morales, was supervising Mr. Boss for those counties. At the time that these warrants came out, Mr. Boss had already left the Jada house. Mr. Boss ended up in Alabama, where he was again picked up new charges. He went to the Department of Corrections in Alabama. The state of Florida had to go to the expense of extraditing him back, or doing a governor's warrant, extraditing him back to this state in order to get these charges resolved. In speaking with the victims in these two cases, the victims are a stranger, Mr. Smith, and Mr. Boss's estranged wife, Miss Jones. What Mr. Boss has admitted to and pled to is that he used Miss Jones' personal Social Security, name, date of birth information in order to apply for a credit card. He then used that credit card, ran up a credit card bill, and then was able to get Mr. Smith's account information. That's how he ended up paying that credit card bill. Miss Jones expressed to me and wanted me to let the court know that this is not the first time that something like this has happened. Miss Jones feels extremely manipulated by Mr. Boss. She feels like the situation has put her in jeopardy. She doesn't wish to have any contact with him. This has caused her credit issues. And again, she just feels extremely manipulated. She is, like I said, scared to have contact with him. And Mr. Smith obviously felt the same way. This money was actually, the money that was taken from Mr. Smith's account was actually a business account. So in Mr. Smith's case, that also affected the financial stability of the business that he owns. So they have been affected. Both of them would like an incarcerative sentence. In fact, I'm sure that they wish that it was longer. The state did explain that, what the score sheet looked like and that kind of thing. But Your Honor, the long and short of this is that Mr. Boss is not a good candidate for probation. The state does not believe he's a good candidate for probation. The department doesn't believe he's a good candidate for probation. He was on probation when these offenses occurred. He fled that probation, went to Alabama, picked up more charges. He was given some leniency and the opportunity to address the drug charge in his probation in Walton and Bay County. And instead of trying to actively seek out avoiding any drugs that might have been available to him, he committed more new charges while he was on probation, and again fled the state and ended up with even more charges. Your Honor, he's just simply not a good candidate for probation, and this is a case where he really has affected people's lives. And this,
what's the state asking for?
The 12.6.
12.6.
Yes. The state does believe incarceration is called for. Again, I don't think he's a good candidate. He does not deserve any more leniency, Your Honor. He has been on probation. He's not a good candidate for probation, Your Honor. And the state, again, states that Mr. Boss's actions had real consequences for real people's lives. And part of what the state, the laws that the state is trying to enforce and uphold is that there has to be some accountability and some punishment for actions. He has been given the opportunity not to be incarcerated previously in this state. He's been given the opportunity at probation. He's failed that probation, and the state doesn't believe he's a good candidate for probation, is now seeking incarceration, and would ask the court to give him the 12.6. Thank you.
May I have your indulgence for just a minute? Talk to him. Sure. Your Honor, just mention a couple practical things. Is I do not think that there is a restitution issue. I don't think the state has raised a restitution claim. I don't know if Ms. Sharpless has any further information, but my understanding is none of the victims are going to be seeking restitution. There could be a no contact provision in the paperwork going forward for the court to give him probation. The last thing I wanted to say is more, I'm not a witness. I might have perceptions about his demeanor originally versus now, and that's really not going to be appropriate for me to try to talk about. I just asked the court to, it's not hard to look at human beings who failed before and be cynical or pessimistic, but Phoenix House is a really good program. It's 12 to 18 months. He's going to have to, whenever he gets back here to jail, he have to sit, wait for his bed. It's going to be better for society, even though punishment is understandably a priority to the legislature, to the state of Florida, to the victims. The total time he's going to have is going to be far in excess of the prison sentence. But I just, I want to see as an advocate, but also as a citizen, I just think it's a great program. It can help turn a life around, and so that he can be what he's aspirational about, as well as the fact that I was totally unaware of this vision problem. Apparently it's a serious vision problem, and hopefully that was one of the things he can work on while he's at Phoenix House. So we want to see a whole human being taking one day at a time when he's out of custody, and I hope that he succeeds. But if he doesn't succeed, if he fails, there'll probably be a whole lot more than 12 months and 12.6 months DOC with credit for all time served in play if that unfortunate event occurs, because he's pleading out to I think it's basically 20 years DOC would be hanging over his head between 22 CF 800 and 23 CF 677. There's a total of 4 third-degree felonies. So prison
I don't believe that's correct, Mr. You got a cap on it.
Oh, there's a cap. There's a cap of 12.6. I apologize, Judge.
I thought the same thing. The reason.
No, yes, that's because there is a cap, and if he violates here, that is an effective cap, isn't it? Yes. With no cap on supervision, so I stand corrected, Judge.
That's all.
My big rhetorical flourish at the end is totally bombed here, but
I'm not sure that would apply to a violation, but
if there were a new law, then it wouldn't apply.
Would not apply to a new law.
Right. Thank you.
And for sure, I'll buttress what Mr. Medina said, that
not going to apply.
as you well know, the criminal justice system is a cumulative affair, and when it stacks on top, the consequences become dramatically more serious. So why don't you come stand up here at the podium? So earlier today I was doing a sentencing. I'm saying there are different types of sentencing, which is some of the hardest things judges do is sentencing. But honestly, this is not a hard sentencing for me. This is an easy sentencing for me. All we're talking about is essentially 2.5 months of incarceration. That's what we're arguing over. And Mr. Medina said something. The state's basically wants you to go to DOC for the next 2.5 months. And you're out, you're clean, you can walk. No probation, no nothing. That's what the state's asking. I don't think that's what's best. Maybe you should serve the next 2.5 months. You probably, you've acknowledged it. It wouldn't be unfair to do that. But I don't think it's what's best for you or the system or anybody else. You're in a situation, and I'm happy for you that you have had the benefit of becoming a Christian. I'm not going to get up here and preach at you, but this is the beginning of, as you know, this ain't the end. It's the beginning of a journey. It's a long journey. It's a lifelong journey. And addiction didn't end when you became a Christian. Right. I'm not laughing. I'm saying that's a journey too.
Right.
And you know that already. It's a day by day, maybe sometimes a minute by minute, right? Journey.
That's right.
Okay. So, while I am hopeful, and I believe in all my heart that you're sincere, I'm hopeful that you don't stray. I'm going to give you a chance. And I think it's what's beneficial for you and for all our society is to give you a chance to do Phoenix House. And what that means, the reason why I say it's easy, the state's asking for 12-6 and no probation. I'm going to give you, credit for time served and sentence you to another 2 years of probation. So you're going to be strung out longer in dealing with state. But I'm going to do as a condition of your probation, bars to bed, Phoenix House. I guess I can't do credit for time. I don't know exactly how we're going to word that, but I want him to stay in jail until he bars to bed in Phoenix House. And then he'll be on probation at that point forward. Hopefully you can take advantage. If it takes you a little while, you're in a good pod. And I have heard good things about some of the programs recently, some of the substance abuse and Christian-based programs in our county jail just in the last year or so. It's great to hear some positive news because that's a tough place.
Yeah.
That's a tough place, probably more than most of us appreciate. Not you, but most of us. So I'm going to sentence you. So I want bars to bed, Phoenix House. Basically, the state's going to have to. They're not going to get their 2.5 months in the DOC because I think this would be better for society. We're going to preserve society. It is primarily about protecting society, but you're going to be off the street in Phoenix House.
Right.
If you don't, you get to spend that last 2.5 months in DOC.
Thank you, sir.
Good clarification on it?
Yeah.
So the court's sentence would be an adjudication of guilt as charged with 2 years concurrent probation between all cases and counts, subject to bars to bed, Phoenix House, and
that is the condition of the probation is participation in and completion of the Phoenix House. So if you decided, like you did with Jada House, that you didn't want to be, you need to go check yourself in so they can pick you up, so they can take you over to DOC, because that's where you'll be spending. You only have 2.5 months left, so if you want to rather spend it there than Phoenix House, you do. I wish actually I could hold a little more of a sentence over your head. I want to give you whatever incentive, and I don't mean that in a bad way. I want to give you whatever incentive I can for you to do this. This is going to be tough, but positive incentive based on your faith and having gotten clean and knowing what it's like to be clean. But you still need that accountability. And it's one thing I've learned about addiction, and it applies to a lot of things, but it really applies about addiction. And that is, you can't do this by yourself.
That's right.
You cannot do this by yourself. Okay? And you've got to develop professional, whatever your support structure, you got to build that. You can't just, when you get out of Phoenix House, decide to come back here and start all over. You got to have support.
That's right.
And it can be professional support. It can be, it can be a counselor, it can be a halfway house. There's a lot of different ways to develop that support. But don't walk out on your own. Do you want to say something?
Yes, Your Honor, a few things.
Did I misstate something?
Your Honor, well, first of all, I wanted to clarify the actual terms of probation so that probation can, but I just want to be clear, it is not my understanding of the law that the cap on the plea to the bench would be applied to any violation.
I believe that it is. And if that is not the case, I'd appreciate you letting me know that. I'm pretty clear that you've capped it, and he's agreed to it. The state has capped it. They capped it. It's capped. Period. That's my understanding.
I will double check that, Your Honor.
Honestly,
I don't think it acts like a suspended sentence, but I will double check that, and if I'm wrong, I will.
No, it's not acting like a suspended sentence. What I'm saying is that it's a cap. So if he came back and say he got credit for time served. Say, let's just use the term 10 months. He's served 10 months. So I'm sentencing him to the 10 months, whatever he's served, okay? So then he's got 10 months. So my point is, if he can't listen to two things at one time.
I'm sorry,
If he violates, then the maximum he could get was the difference between how much he spent incarcerated versus your cap that you agreed to. That's my understanding. And if that's not true, let me know for future ones, because I want to know that.
Mr. Medina.
Your Honor, I apologize for my confusion. Perhaps it's, I think that because it is not a suspended sentence, that Ms. Sharpless is correct, and that maybe that I was originally correct, that he would have
maximum
basically because there's no cap on supervision. So if the court sentences him to 24 months concurrent probation, I believe there would still be, if he violates, I think he's subject to the statutory maximum on the charges. I think that Ms. Sharpless and I can, brief that for the court.
I would appreciate it.
I just want to make sure that Mr. Boss knows that wasn't my understanding, so I don't want him to.
No. You don't want to say, hey, the judge said this and hold me to it.
Because had it been a suspended sentence,
the court would be correct if the state agreed to a suspended sentence, then that would be correct.
If it had been a suspended sentence, because we've had that a couple of times over the last year or two, where with the suspended sentence, absent a new law felony, that is absolutely
that acts as a cap on incarceration.
Okay, but give me a meeting, just throw a case or two at me, with
yes,
an email.
Ms. Sharpless and I will confer and provide the court some authority on that subject, so that.
So with that,
you've got the real incentive.
Understand that, Mr. Boss. What that means then is that you are at risk if you violate. That doesn't change what I'm going to do. I'm still ordering you to.
All right.
Your credit for time served and an additional 2 years of probation. So when you get through with Phoenix House, you'll have a couple more months on probation. Hopefully that'll help maybe set some things up.
Right.
Even though probation isn't necessarily, but they can act in that capacity with some support to help point you with some services and stuff.
Well, thank you, Your Honor, for the chance to change my life.
No, you've got to act on it.
All right.
You've got to act on it, and
I will.
I know. I'm not here saying, oh, everything's perfect.
Right.
I'm not naive. I've been on this bench too long to be naive. Mr. Medina?
Yes, Your Honor, just a couple of details. Number one is that I think there would be $515 in court costs times 2, and also a total of $250 public defender fees, including $50 application fee. And finally, because he
so you'll be able to pay that throughout the terms of the probation.
Yes, sir.
So just try and it's like eating an elephant. You don't have to eat it all at one time, but take
Some
one
pieces.
bite at a time. Do that with your stuff. So you don't wait until the end of your probation. Now
That's
they're looking
paying
there for a couple grand out of you, and you don't got no money, and now they're trying to violate.
Right.
And you don't want them going against your driver's
Of course
license
not.
and stuff like
Right.
that. You're on the other one.
I'm sorry. Yes.
Thank you, ma'am. The other thing I wanted to just put on the record to be clear is that there would be because it's bars to bed, Phoenix House, would the court have any objection to his transfer to the other counties, and then he'll come back here to do the bars to bed portion of it? So no objection to transfer to other counties that have pending VOPs.
That is not my intent. My intent is only to deal with what we're doing here. I know the other stuff's got to be addressed, but I don't know exactly how that is, so I'm not trying to be an impediment.
All right.
Yes. So you'll probably get picked up and transfer, and then you'll probably head back to. But you are on bars to bed. Okay. When and if you get out, when and if you walk out of jail in another county, you got to report back to jail in Okaloosa County.
Okay.
And also make sure that probation in Okaloosa County is always fully informed as to your whereabouts.
Of course. Of course.
With probation, do you have anything you need?
We need to,
I just want to ask regarding contact with the victims.
I was asking for no contact, Your Honor. Your Honor, is the court, what type of probation is the court ordering for 2 years? Is it standard probation, drug offender probation?
It's prerogative of the court, Your Honor, to whether it was.
I'm just gonna do regular probation because.
I just want to make sure.
The condition of it is gonna be, the majority of the probationary period is gonna be at Phoenix House. At least half or 3/4 of it. And so you're really talking about just that last 6 months or a year when you get out.
And can the state ask the court, I haven't received any restitution forms from the victim, but can we reserve jurisdiction on restitution, just in case they call back? I would prefer that.
Well, the state did not request it initially. And I made a ruling, and I'm gonna stick with my ruling, and that did not include restitution. It wasn't requested, I didn't address it, and I made my ruling, so I'm not gonna include that. I'm gonna include the no contact, that was mentioned, no contact with the victim.
And is the court ordering substance abuse evaluation and treatment as a part of this?
I'm sending him to, the condition of it is to go to Phoenix House. Isn't that a substance abuse
That usually
program?
is a proxy for substance abuse evaluation treatment. Commonly, when people have inpatient treatment, it takes that place.
If I need to put that in there in order to get him evaluated by Phoenix House, I'll put it in there, but
I don't believe it's necessary, Your Honor.
And is the court ordering random urinalysis as a part of his probation?
is that what they do at Phoenix House?
They do that already at Phoenix House, sir.
When he gets released, basically my understanding is he'd be on regular probation, subject to the discretion of the state probation.
Without that special condition, isn't that a condition of regular probation, random UAs, or does that have to be put in the order?
We do test him randomly, but if you make that a special condition, then that just adds on to his probations.
If you all do it as a matter of course, I'm going to leave it up to your discretion. That'll be, like say, we got 2 years probation, you're dealing with 6 months or so of actually supervising. I mean, you'll be supervising while he's in Phoenix House, but not kind of so much hands-on because he'll be in Phoenix House. You all dealt relatively frequently with Phoenix House, haven't you? I mean, that's one of your.
Yes, sir. I want to say it's the Ocala office that supervises those in the Phoenix House.
Okay, but it's not uncommon. We've sent a good number of folks over to Phoenix House from Okaloosa here.
Yes, sir.
Okay.
It's Marion County, and Your Honor, my understanding is if state probation in their discretion wants him to be tested every single day, basically it's officer direction. He has to comply with whatever their directions are, so it's officer discretion to require whatever.
I say if they feel like they need it, I'll put a condition in there, but if it's already there,
I think it's a general condition that they have the authority to require.
Your Honor, I just want to make sure with probation that no firearms is while on probation. Is that a part of the?
Firearms, no drugs unless otherwise prescribed.
I just want to make sure.
I know we've often put that in the agreement, but that's standard.
It's standard.
Standard provision. And you can rest assured, you will be UA'd during this probation.
Yes, sir.
And then Ms. Sharpless and I will brief the court just informally regarding this issue, but he needs to assume that it's hanging over his head.
Right.
Yeah, take back what I said about that cap, and it may be the full 20 years is the max of the 4 counts.
Thank you.
Thank you, sir.
So this way. John, what's the last one? Uni.
Well, that was a nice